Hello, honorable members of clients. So, welcome to my YouTube channel, and let's go back to the Senzo Mayo murder trial in the North Gauteng Pretoria High Court, where I was a little bit surprised. Like, wait a minute, I thought this is Mr. Baloy responding to Mr. Ngumalo's application when it comes to section 174 for accused number 4, who basically says, I wasn't there. So please let me go and continue serving my sentences of other crimes that I may have committed in the past and convicted for. Not the sense of Mayo. I wasn't there. I wasn't there. And out of the blue, I hear Mr. Baloy handing his response to his colleague, that is Mr. Sibanda, or Dr. Sibanda. And I was like, oh, help us all, not Sibanda. And just like I thought, Sibanda was no different. And I don't think Dr. Sibanda should be in court, in my opinion. I mean, you have a doctorate in law, right? I think you should just be lecturing, sir, or just become a law professor. Courtroom are not for you. That's my opinion, because you confused me even more. But I want to focus my attention towards the end of Sibanda's submissions to the court, because everything else I decide to do other things and just forget about it, because he infuriates me. And I don't like to be infuriated like that, especially by somebody as educated as Dr. Sibanda. But the challenge that took place between Mr. Mnisi and Mr. Sibanda. Mr. Sibanda introducing, and I support what Mr. Mnisi is saying. This is the introduction of new evidence, and they are talking about an irrelevant person here, accused number 3, instead of focusing on section 174 that was being applied for by accused number 4. But now he is coming up with accused number 3 and what he said at a lower court on the 27th of October 2020. Like, I was like, what is going on, sir? What is this about? And of course, Mr. Mapisa, accused number 4, was like, hey, what's going on? I want to hear those records. I want to hear. That's when Mr. Ngumalo said, we want to, my client wants to hear those records. Mr. Mnisi himself was like, no, this is new evidence, and if the state wants to reopen its case and then slide in this particular information, they can do so. Because from where Mr. Sibanda was standing, he believes that as the state, they can do as they please. I mean, it is their case after all, and they are the ones who are responsible to prove their case beyond a reasonable doubt against the 5 accused persons in the unaliving of Senzo Mayo. So, of course, clearly there was support from the presiding officer, Judge Rata, who went as far as pulling an authority from 1949 and even said, I was 2 years old when this judgment was made. And it was about recordings that were done. They are still relevant, I think, of that, something of that nature. I was bored. I was bored, guys, seriously. But what got me excited was Mr. Mnisi getting up and challenging Mr. Sibanda regarding this new evidence that he was trying to slide in, as they've been doing since the beginning of the trial. And of course, with the assistance of the judge, in my opinion, that trajectory has not changed, or the trend has not changed since the start of the trial. But I don't want to take too much of your time. I will let you see what actually transpired in the next clip between Mr. Sibanda, or Dr. Sibanda, and Mr. Mnisi, and Mr. Mnisi standing up for his client, accused number 3, and Mr. Ngumalo standing up for his own client, accused number 4. And then at the end of, or towards the very end, then there was this a bit of a, how do you put this? The interpreter. I always thought that the interpreter will speak after the English version, but no, that was held up. all the way till towards the end of the case. And Mr. Jonas, who says that he will not be able to do 34 pages in 30 minutes to interpret what transpired in court yesterday. And I was like, okay, so then what do we do? Because you're talking about you having to be in Johannesburg and your guys are recruiting and all of that. Oh, Mr. Mshonolo stood out fiery and said, this is unfair to our clients. And I agree. It's quite unfair to the accused when proceedings were taking place the entire day and they were in total darkness. And then Judge Rat is like, these gentlemen, they understand. Whether they do understand English or not, Oksalayo, there are Zulu-speaking people. If there were not Zulu-speaking people, Xhosa or Venda or Tsonga, what matters is sometimes even myself, who does speak English probably 75% of the time, I would still want isiZulu to be interpreted, to be spoken to me. English interpreted into Zulu. So what if they understand? So what if they can perfectly say certification of documents? Like, I don't understand that argument anyways. Guys, without further ado, let me show you this clip.
The Exhibit S, what Ms. Pinkifa Ifilingem has told the court, what he has said through his lawyers, Mr. Mnisi, as well as Mr. Ngomalo, that they were enjoying this joyride in a Kumbi with Sigayo, Falka, Telimpido Daonde and others. He was not in custody. He was outside when the deceased was shot and killed. That was his first.
Where do you get that evidence?
Exhibit EE, my lord.
EE. What does
That's
EE
correct.
say?
It's a transcribed record of the first appearance at
Yeah.
Prospect.
Who was making that declaration?
Accused number 3.
Through his attorney. Sorry.
Himself,
counsel.
personally.
Hello?
He made it directly to the court.
Oh, personally.
That's correct.
He tells the court, when this thing happened, I wasn't around Joburg.
I was incarcerated.
Or Gauteng, I was incarcerated.
That's correct. The record is there. It speaks
It's
for itself,
recorded.
my lord. We have the transcribed record is before
No,
court,
fine,
my
fine.
lord.
No, I just want to know if it is. Then I'll check it.
That's correct.
And Mr. Ngumalo, what does he say?
No, it can't be checked.
Hello?
It can't be checked later. It must be checked now.
No, you don't know about that.
No.
Okay, fine. If you don't know-
I've never heard
If you
it.
don't know about that,
No, it's
fine.
news to me.
Okay, it's news.
May I also make a follow-up, my lord, because
never
it affects my client very directly. The court will note that this is not a time to introduce new evidence.
It's not new evidence, Mr. Mnisi. If it's recorded,
I am not saying that
if
this
it's
is new
recorded
evidence.
before Mr. Ngumalo started addressing this court, it can't
Yes.
be new evidence.
My lord, I am saying,
Yeah.
and if the court can hear me, and please
Okay,
hear me well,
yeah.
please. I'm saying this is not a time to introduce new evidence. And that information that Advocate Sibanda says before he sits down, he wants to introduce it, should have been information, had it been brought to our attention. If that was the state's case all along before they closed their case, definitely that information would have been a subject of a trial within a trial to determine the circumstances under which accused number 3 allegedly said all those, whatever it is alleged that he said it. But now that he says it now, my lord, now that it is said that he said it then, but that information is being introduced now.
No. You're talking at process purposes. According to your colleague here,
Yes.
the doctor, he says this was said at the first hearing.
I'm going to request.
It's like a plea.
Yes.
First day you plead guilty or not guilty, and you say not guilty.
No, it can't be like a plea, my lord, because there's a specific format that prerequisites that lead to a plea. In other words, precursors to a plea. They explain your rights to legal representation. You make a decision whether you're going to conduct your own defense, whether you're going to be assisted by legal aid, or whether you will have your own attorney, and the implications of you saying something. That must be explained to you. So we don't know if those circumstances before accused person actually uttered what it is alleged that he uttered, those circumstances were explained to him, which is the reason why I say, if the state wants to rely on that information, it should have been something that was brought to the attention of accused number 3 in conjunction with me, so that we map a way forward as to the admissibility of that information. But as is now, that information is totally inadmissible. Unless it should have been a subject of a trial within a trial, my lords.
Let's hear, Doctor, what are you saying? You say you can't use that information.
I'm accused number 3, my lord.
Yeah.
The request to see me.
Okay. Have you read of a case called State versus Nkoshe, 1949? Anything, that decision says basically, anything which says by a counsel or his word in court, it's recorded.
That is correct.
Everything. 1949, so I was 2 years old. Yeah.
I'm instructed by my client that he would want the record of the 26th of October. Sorry, not 26th. Of the 27th October 2020 when they appeared in Boxback, because to him it's news.
Yeah,
news. I've also never heard about that. Thank you.
As it please the court.
We've got it, that record. Remember there was a dispute about what the magistrate should have said and didn't say. And then somebody brought the typed record. Is that not so? Of the 7th of July. 27th July, sorry. Yeah, you're right. Okay, fine. So you want to see the record?
We want that,
They say they want to see the
we want
records.
that, charge sheet.
The record?
The charge sheet of, reflecting the date of the 27th of October
Okay.
2020.
Yeah,
I
fine.
thought,
This is mine. Oh, this is.
I thought Mr. Ramosipil will bail me out as an attorney because this information, when we introduced the information, it pertained to his client, and it was discovered during trial within the trial when we were dealing with the issue of. But when we introduce a document, we do not say this document only binds this one. It's a document before court. You can use it anyway, anyhow you want. The document was disclosed. Mr. Ramosipil can bail me out. I trust him to do that. He knows.
He knows.
Yes.
No, but it doesn't answer to our concerns. Still.
We cannot just disclose a document, my lord, to Mr. Ramosipil. We disclose to all of them.
Okay, fine. So
But if they want the document to be disclosed, I can email it to them now, or we can print copies.
Yes. Print the entire.
But for now, my lord, I'm going to read what accused number 3, said.
yeah, okay, fine.
But before I do that, because I know this court wants authority,
Yes.
so I'll start with the authority.
Yeah, fine.
Section 235, subsection 1 of the Criminal Procedure Act, proof of judicial proceedings.
As it please the court, my lord, that is exactly what I said. This is an application for a section 174. This is not a time of looting evidence. And this application has got to do with accused number 4. If the state wants to reopen their case, they are welcome to make an application and say, having traversed the application in terms of section 174, there is this other information that we also want to introduce that relates to accused number 3. May we kindly reopen our case? But things cannot be done haphazardly the way in which it is suggested that they should be done here, my lord.
I haven't heard what Dr. Sibanda, I don't know what he wants to say.
No, he says exactly what I'm
let him
explaining
repeat-
to the
let him
court,
re-
my lord.
let
He
him
wants to
say-
introduce this new evidence.
Let him say what he wants to say. I don't know what he wants to say. What do you want to say, sir?
My lord, I was just making my last submission to say this is what accused number 3 said during the first appearance, and then there was this.
And then you said that you wanted to quote something.
I wanted to quote to say, but this evidence already is before court, and then it was brought in terms of this section, proof
Yeah,
of
so
judicial
let's
proceedings.
tell us, educate us about that section.
Section 235, subsection 1 says, it shall at the criminal proceedings be sufficient to prove that original record of judicial proceedings, if a copy of such record certified or purporting to be certified by the register or clerk of the court or other officer having the custody of the record of such judicial proceedings, or by deputy of such registrar, clerk, or other officer, or in the case where judicial proceedings are taken down in shorthand or by mechanical means by the person who transcribes such record proceedings, as a true copy of such record is produced in evidence as such criminal proceedings, and such copy shall be prima facie proof that any matter purporting to be recorded thereon was correctly recorded.
Okay.
That's it.
And so what was recorded according to you?
And then I want to place on record what was recorded. And I'm just placing that relevant passage. Accused number 3. Okay, I'll start with the court. No response from accused 1. Accused 3, Mr. Mnisi, do you wish to respond to the explanation about legal representation? Your Worship. Accused 3, Your Worship, I do not see the necessity of having a legal representative because I do not know why I was brought before court. I will not enter the accused dock, Your Worship, because I do not feel, then there was no recording. Your Worship, the police officers, they were with other people. They came to us. It is alleged that at the time of the incident that we were outside, and it was later discovered that we were actually incarcerated. On actually what had happened, and that again, Your Worship, and decide as to what happened, and again, Your Worship, our constitutional rights had not been taken into consideration in that regard. So even at this time, Your Worship, they are not taking our constitutional rights into consideration, and that we, the people who actually committed that offense, they were outside, and that time we were incarcerated.
Okay.
And the date of this was 27 October 2020, and what I was reading is on page 4 and 5.
Yeah, fine.
Then I will pause here, my lord.
Okay.
Well, that's what transpired. And guys, please don't leave the video without liking, sharing, commenting, and subscribing. And I'll see you next time with a new video. Goodbye.